Welcome to Mississippi Divorce 101. I'm Wendy Hollingsworth, and I am going to explain to you some of the basics regarding obtaining a divorce in Mississippi. Mississippi's divorce laws are unique. I believe we're the last state in the nation without a true, unilateral, no-fault divorce. What that means is, although you can obtain an irreconcilable differences divorce in Mississippi, it requires the consent of both parties. If either party refuses to consent to an irreconcilable differences divorce, then the party who wants the divorce must prove fault grounds. There are 12 fault-based grounds for divorce in Mississippi, but most of them are very rarely used. The most common grounds are adultery, habitual cruel and inhuman treatment, willful desertion for the space of 1 year, habitual drunkenness, and habitual and excessive use of drugs. If the party who wants the divorce cannot prove grounds for divorce, and their husband or wife won't agree to consent to an irreconcilable differences divorce, then they cannot get a divorce in this state. Yes, that really means that they might just have to stay married. But let's assume that both parties can agree to obtain an irreconcilable differences divorce. If that is the case, what usually happens is that the parties will file a joint petition in their county of residence. The joint petition is a plain, vanilla document that establishes basic facts such as who the parties are, that they've been residents of Mississippi for at least 6 months immediately before the filing of the petition, and that they agree to get an irreconcilable differences divorce. Thereafter, the parties will have to enter into a property settlement agreement that adequately and sufficiently settles all issues concerning their division of the assets and liabilities, as well as custody, visitation, and support for any minor children, and any alimony. If the parties are unable to agree upon some or all of the issues, then they may agree for the judge to decide those issues which they cannot agree upon themselves. Either way, for an irreconcilable differences divorce, there is a 60-day waiting period between the filing of the petition and when the final judgment may be entered. Although divorce is seldom emotionally easy, if you and your spouse can agree upon an irreconcilable differences divorce and property settlement agreement, it makes the legal process relatively simple and inexpensive. It can also minimize a lot of hard feelings, which is especially important if the parties are parents who are going to need to work together for a long time in the best interest of their children.